everybody. Respected Sri Kumaran, Principal in Charge, Government Law College, Kozhikode, my alma mater. Sri C.C. Joseph, Assistant Professor, Government Law College, Kozhikode. My friend and Director, Kerala Judicial Academy, Sri Anandakrishnan Navada. Sri Bibin Jose, Additional District Probation Officer, Kozhikode. Subhash Kumar, Joint Director, Directorate of Social Justice. Other dignitaries, dear students, friends, once again, good evening for one and all. I'm very happy to attend this function. And at the outset, I would like to congratulate the LJRF and the other team for organizing such a wonderful program. It's an internship program for 1 week on probation reforms, probation law reforms. Probation Offenders Act. It is the most underutilized enactment in the Indian legal history, I may say. I was a magistrate for 12.5 years continuously, and thereafter as session judge for another 6 or 8 years. But I used to say that in every meeting with regard to probation offenders, I have applied or given the benefit of PO Act only in few cases. And the latest one, I have done it in a POXA case where a doctor is prosecuted under section 19-21 of the POXO Act. That's for failure to report a POXO offense. The doctor was first found guilty, and I applied given the benefit of section 3, and she was warned not to repeat such offenses. That was first case where a doctor was convicted under section 19-21 of the POXO Act. As you all know that Probation Offenders Act is applicable to all except where the punishment is life in death, capital punishment and life imprisonment. So we can apply all other offenses. But there are recent legislations which mandates or specifies that there should be a minimum sentence. For example, in the POXO case itself, most of the offenses, the minimum is specified. Then there is a question may arise whether this Probation Offenders Act can be applied to the POXO Act and such other recent legislations. I am personally of the opinion that unless there is specific exclusion of the application of Probation Offenders Act, this can be made applicable. But going by the ruling of the Apex Court and the High Court, for the time being, when the statute prescribed minimum sentence, there is no question of application of Probation Offenders Act. The reason behind is that whenever a new legislation is made, the legislature is aware of the existence of such a provision, such an enactment as the Probation Offenders Act. Still, the legislature feels that it is necessary that in certain offenses or certain acts, it has to be taken very seriously, or you have to give a minimum prescribed sentence. So when such a minimum is prescribed, there is no question of application of PO Act in view of the ruling of the Apex Court and the High Court. But you may ponder, or you, the students and the academicians may think of, or even have debate on the topic whether the PO Act can be applied in the other enactments, just like the POXO Act, etc., where the minimum is prescribed. My view on that aspect is that PO Acts, when even for every offense, if the court finds the person guilty, and it is mandatory that we have to apply our mind based on the other facts and circumstances whether we can apply the PO Act. Once you apply, once you are giving the benefit of PO Act to the accused, then in my view, This should not be a barrier, or this provision should not be a barrier, or the minimum sentence prescribed should not be a barrier for applying the POAC. Because in my view, the minimum sentence is prescribed when the court is going to give the punishment, the sentencing, when what is going to impose the sentence. Then, of course, the minimum sentence has to be provided. That's my personal view. Of course, we have to follow the ruling of the Apex Court and the High Court. But I have just mentioned that aspect in this because it is an academic session. The people can think of it, whether it can be applied to new enactments or whether it can be not applicable to such enactments also. And we are discussing about the internship is regarding probation reforms, probation law reforms. It's an act brought in 1946. It is an act, I think it was never amended. Almost all other enactments which came even before that or subsequent as subjected to several amendments. That still stands unamended. And as I've told you, that is an underutilized enactment. It has its own reasons. Why? The opposite. But we are giving a training for the judicial officers and even the lawyers and all the stakeholders regarding the application of Probation Offenders Act. Even the last March, we did a program, an awareness class for the entire judicial officers of the state, operation of the Social Justice Department. And we are trying to make the judges more aware of, we are giving training in order to ensure that this act is being applied in wherever it is applicable or what is possible. By reducing the incarceration, that is putting persons in jails. In all our jails, whenever I used to visit jails as part of my duty, you can see there is 200%. When 100% is the capacity, there will be 200%. There are overcrowded jails in our state also. So application of PO Act will serve to a certain extent to reduce this overcrowded jails. Apart from that, you people were well aware of that recent amendment in CRPC, thereby making a difference in cognizable offences. Cognizable offences which are punishable up to 7 years and cognizable offences which are punishable above 7 years. Now, going by 41(1)(b) of CRPC, generally, in cases where the offences is punishable up to 7 years, there shall not be an arrest. But the police officer has to summon the person by issuing a notice under Section 41 Capital of CRPC for questioning and other purposes, for investigation purposes. So, up to the offences where the punishment is up to 7 years, normally there shall not be arrest. Such restrictions or such provisions are incorporated in CRPC. This amendment was brought in order to reduce the crowd in the jail. As you all know, when a person is arrested, then you have to take bail, and sometimes even if it is bailable, there may not be a person to take him on bail, then he has to continue in jail. And also we have to consider while studying the probation laws and probation reforms. With these few words, I conclude my speech, and I thank the organizers for giving me an opportunity to address the young talents. And once again, congratulate you all. Wish you all the best. Thank you. Jai Hind.
അങ്ങനെ നോക്കുമ്പോൾ നമുക്കിത് മനസ്സിലാവും. See, 80 Article 80 is what about the composition of the council of composition of the council?